Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Wildy, Simmonds and Hill Publishing. It's part of the Wildy's Legal Handbooks series, this particular book. It's a series of books, in fact, and this one is called Bilateral Investment Treaty Claims, the Essentials, and it's been written by Khawar Qureshi, Queen's Counsel. Elizabeth and I talked about the book and we've given it a review title for the review, which is on the web and in the journals, of the following: a practical short statement on the essentials of bilateral investment treaty claims, or BIT claims. Let's have a look at the book. It's a small paperback. There it is, blue colour paperback. There's the front, there's the spine, and then on the back got a picture of the author and some basic information about him and about what's actually in the book itself. It's a very small book. It's very useful. There's no index at the back. It runs to 200 pages. That's the very last page. You can see that what you've got actually at the back is a series of annexes. In fact, this is the last one, is Annex 3. Let's go to the front and you'll see a little bit better, I think, what in fact the book contains. There is actually the front cover. These are the other books in the series which are listed there. That's Public International Law Before the English Courts and Conflict of Interest in International Arbitration, an overview. Then we've got the basic information from Wildy, Simmonds and Hill. Then we've got the contents, which are set out in this particular way, and it's the same with the other two books that he's published. It's the checklist that is most important. There we go, there's the second page of the contents. They're not numbered, but they're just a series of headlines, and then there are three annexes. There's the sample bilateral investment treaty, the relevant legislation and recent arbitration decisions. Then there's the foreword by Christopher Schroer and Rudolf Dolzer. Then there's an introduction about the actual book itself. There's some background which is quite useful too for anyone new to this area. BIT disputes a rapidly expanding and high-profile area of international litigation, and of course London is still very prominent. There's the key issues statement. London is very prominent in this. You do have a nice little bit of shaded area to find the actual points. That's key issues. Then you've got the checklist itself and so forth, and the book runs through in that way. There's no footnoting and there's no paragraph numbering. In fact, when I say that, there is a little bit of footnoting I just spotted there, but not very much, very, very little in fact. So that's the book. Now, what do we say about it? Well, it's only a short review, this one. We say that the author, Khawar Qureshi, Queen's Counsel, begins this excellent short work with the following statement. There's been a huge increase in investment treaty-based arbitration claims against states in recent years. That's sort of repeated in different ways at the beginning of the book. To fill the gap then, Qureshi has written this title in the Wildy's Legal Handbook series, and BIT disputes are continuing to expand rapidly as a high-profile area of international litigation. So therefore the appearance of this handbook at this time is most welcome. I wrote and recorded the review of this book at the beginning of 2017. Now, bilateral investment treaty claims are specifically, the book itself and the claims themselves, they're specifically aimed at practitioners and state legal advisors who need to identify and understand the key elements which underpin BIT-based claims by reference to the leading arbitral decisions from the ICSID and the UNCITRAL Investment Treaty Tribunals. Now, I'm using some abbreviations there, but you will of course see some of the abbreviations in the book itself. It's the ICSID and the UNCITRAL tribunals. Now, the two people who've written the foreword, that's Christoph Schroer and Rudolf Dolzer, say that their significance, that's the basic significance of the claims, is usually discussed in terms of the impact on investment streams and thus economic development. So it's not just a question of law, it's a question of politics and economics, of course. They go on to say that, quote, a frequently overlooked aspect of BITs is their effect on international relations. If you think about it, it must be the case, especially bearing in mind what we're facing now in this country, which is Brexit. It's therefore to the international aspect that this book dwells. Diplomatic protection, quote, by the investor's state of nationality, was a good excuse, this one, it's a convenient way of dealing with the jurisdiction issue, has been exercised because of often ill-defined principles and was therefore a frequent source of irritation and discord. And may I say at this point that this is a much wider problem for international law. We're going to see it with the renegotiating of trade treaties across the globe because of Britain's decision to withdraw from the EU, and that is going to show up the real problem that we have internationally with a number of different agreements that we have. The classic example, of course, in a much wider sphere is the internet and control thereof, which of course is virtually non-existent, and it allows people to do all sorts of things which are frankly criminal. Now that is the problem, and it's not going to go away, and it will be during this century a time for us to start looking again at much more cohesive treaties and arrangements between states. But that's obviously for another day. However, getting back to the book, with the creation of legal rules in a hitherto largely unregulated area, BITs have depoliticised disputes and brought a measure of legal security. I'm not sure that's right. Now, Schroer and Dolzer conclude then that, quote, in the presence of objective treaty standards supported by an effective investor-state dispute settlement mechanism, the host state and the investor's home state are less likely to be drawn into investment disputes. And that, of course, is the whole raison d'etre for really trying to resolve these matters before they escalate. They also comment that the Handbook is a most useful manual for practitioners and students alike, and it offers a practice-orientated review of the most important features of BITs and their application by tribunals. And again, I think it's an area that is probably not known to a lot of people, but it's probably an area which is a growth area. Hopefully, of course, many readers will be familiar with BITs, so that the initial 4 chapters of the work, which give the usual background to BITs, will be helpful. And of course, the key features plus a checklist for practitioners contemplating or being involved in a claim under a BIT are of course most welcome. Now, the penultimate chapter describes additional considerations, citing leading case law dealing with the scope for preliminary measures in BIT cases. Also, it covers abuse of process and illegality, and there are 2 excellent and detailed annexes to go with that, and then a third, of course, right at the end with cases. The author has generously donated all royalties to the Bar Benevolent Fund, and we thank him very much for that. Let me conclude by saying it's a most useful new manual from Wildy's to go with basically the series that we have for both students and practitioners alike. And what we particularly found favour with was the practice-orientated overview of the most important features of BITs and their application by tribunals to give us a refreshing insight into what is a developing area of international law. As I've said, the rider to that is that we do need to have new agreements, and we're on the cusp, I think, of going into that direction now with the withdrawal from the EU and the need certainly for Britain to start looking again at the type of deals, if I can use that expression, and arrangements and agreements that we have with other countries across the globe. The current law is stated at January 2016, and I'm recording that a year on. But let's have a look again briefly at it. Qureshi's book is very good indeed. There's the front, there's the spine, then there's the back. There's a picture of him, you can see there. Now, just opening it in the middle, this is actually the role of national courts. Quite useful. Let's just go to that bit here. The role of national courts. There we go. That bit there, about halfway through the book. This is obviously looking very specifically at national courts and how they operate. Of course, the important thing about this country is that a lot of people do come in. Now, Mr. Qureshi, of course, is a Deputy High Court judge. Has been since 2014, so he's got a very great deal of experience of where we're going. And what I did say, I did mention the last annex, Annex 3, is actually case law, and that does in fact come in as a most useful additional annex. But it's a good little book, this one. I'd like to thank all the people involved, Wildy, Simmonds and Hill in particular, for undertaking the publication of this and the other other titles in the series. But I think this is a welcome addition to our understanding of international law. So thank you to everybody concerned. Bye-bye.